Hi guys, it's Kathy. I hope you're doing well. So this is part 2 from yesterday. Yesterday we had this case where there were dogs outside barking, and a neighbor came out and screamed, get your effing dogs inside, or something like that, a little more harsh. And a 10-year-old boy heard it. So he got scared, and they called the police on this man. The police came and arrested this man. His wife was there. Even they said the wife was the more of the aggressor almost all the time. This man hardly never. But, hi Linus. So this is what we listened to yesterday was the state's case in chief, but I worked yesterday, so I got a bit from yesterday. I wrote a piece of code that was supposed to pick up this link all day long and just get it if it went live, and it sort of worked and it sort of didn't. I didn't get everything from today, but I got a lot. So we have an ending. It ended. We know what happens. We have a verdict. If anybody wants to guess what the verdict is. So I have a short 3-minute clip, and then it just cuts off. And then it starts back up. Yep.
Next witness was Kendra, the child's mother, who testified she was in the house and she did not hear the statement uttered towards her. She did not have the statement, therefore, directed towards her as an adult, and that she relied upon what her son said when he came back in the house. We then turned to the next witness, Alex Woods, who was the neighbor across the street. And Officer McCheeson said that he went into the backyard and heard the statement uttered, but that is not true because Alex Wood testified from the stand that he was across the street in his driveway where he heard loud shouting and heard something to the tune of, "You're effing dogs," right? So it is uncontested and uncontroverted that Alex Woods was never in the backyard, not an adult to whom any conversation was made in his proximity or otherwise. In fact, there's no evidence before you whatsoever to suggest that John Danielson knew that Alex Woods was present or in his driveway with his family or not. But again, that's not the case that the state is bringing. What we are left with, Judge, is a set of facts that are a 10-year-old child, Luke Adams, went outside on August 28th to let his dogs out. How many we don't exactly know. How long we don't exactly know. But we do know that my client was frustrated and he yelled something from 200 feet away to the tune of, "Put up your effing dogs," or "Take care of your effing dogs." Now, if you look towards Lynn, and I originally asked for a jury charge on this yesterday concerning constitutionally protected free speech. That's what's at issue in this case. And our Court of Appeals has said that the criminal statutes are to be very narrowly construed so as to require any charge or conduct under this statute to involve the use of fighting words that result in or are designed to result in the hearer of those words being provoked into fighting, or to threaten, and this is a critical word, the immediate breach of the peace. So, Judge, immediacy is a word that the Court of Appeals relied upon because it contemplates proximity of the parties and the allegations of the statement. I'll tell you in the LEN case, the statement, which eventually, I think it was reversed, or if not, it was dismissed, and the appeal was dismissed. But our Court of Appeals said in that case that the statute had not been violated, even though they were in close proximity one another, because the words weren't designed to provoke another person to fight. In the LEN case, it said, I better get my effing Sharpie back. So the LEN case talks about the excited use of profane language regarding the property at stake, the Sharpies, are not such a statement directed at another person, right? The use of personal epithets or things like that designed to make you fight. Things such as, I dare you to effing come out here and do something about it. That would be fighting words under the statute. That would be, if those words were used in the presence of a 14-year-old child, I think you could reach the conclusion that
I think you can reach the conclusion that, and that's where it stops. It starts again, don't worry. But that's fine. We heard enough from him. Linus, thank you so much. Thank you.
Your vantage point, is that correct?
Yes.
You've watched them enough where you've seen their habits and that they don't go inside the house, is that correct?
Correct.
So do you just stand out there watching them?
No, like I said, my deck is over their yard. You see what's around you. I don't wear blinders when I'm outside. I notice my environment.
Okay. And you testified that you haven't heard the dogs barking when you're leaving in the mornings. So you would agree with me that they can't be barking all the time, correct?
Well, I believe I also testified that there are times when there's nothing going on outside, they do calm down for a while. So that would also be that it's not all the time.
Okay. And on this particular evening or afternoon, you testified that you didn't see anyone, right?
There were no people in the backyard at the time I yelled.
Okay, but you heard a female voice.
Yes.
Okay. But you knew children lived at the house.
Correct.
Okay. So would you agree with me that just because you didn't see Luke Adams in the backyard doesn't mean he wasn't there?
I mean, he wasn't in the backyard because I can see their yard.
But you testified that you weren't looking at the time that you screamed it.
I was looking at their house. I have to look through their backyard to their house.
Okay. No further questions, Judge.
No redirect.
Okay, thank you, sir. You can step down.
Thank you.
Call your next witness.
No witnesses, Judge. That's my case. We rest.
All right, any rebuttal from the state?
No, Judge.
All right, ladies and gentlemen, with that announcement, you've heard all the evidence you're going to hear in this case, and this is what we're going to do. Let's take a 5-minute restroom break, and then we're going to come back and hear closing arguments, and then the charge from the court. Y'all have this case shortly, okay? Take a 5-minute restroom break, and we'll come back and get started with the next phase. Anything else we need to talk about with the charge?
Yes, Judge. Just for the record, I want to renew my motion for a directed verdict in light of the testimony that was given. What we now have is uncontroverted evidence that the mother said, say something Mickey Mouse, after the first attempts with no profane language to get the dog stopped barking. It has been unrebutted, uncontested, that the mother said, say something Mickey Mouse. Now, when Kendra was up here testifying, she said something to the tune of she said something to him, but couldn't remember what exactly it was or whatnot. Judge, the testimony uncontroverted and unrebutted is only then did John respond with, put your fucking dogs up, or take care of your fucking dogs. That's what he said. Judge, the first and threshold element of this case is without justification. So in other words, the state has to prove that element beyond a reasonable doubt that there was no justification. And I believe that you...
Provocation.
Provocation, sorry. There is provocation. And you should be able to find that it was adequate to justify the word used. So if you do find that, and you find that the state has no ability to argue there wasn't provocation or justification, I think you're allowed to direct a verdict under the testimony as you've now heard it from my witness stand. I'll renew my motion for a directed verdict.
Ms. Post.
Judge, I don't necessarily agree with Mr. Tumlin's characterizations that there's no evidence in regards to the female and Miss Adams and what she said. She just simply said she didn't remember. That's not to say that it necessarily didn't happen, but I believe that that's for a jury to determine whether there was or was not provocation in this case, regardless of the fact that Luke testified he was present in the backyard. Provocation based on something that Miss Adams screamed, Judge, I believe that that's for a jury to decide.
All right. I still had to view the evidence in the light most favorable to the non-moving party, and I think the testimony's in conflict. The testimony from the Adams was that this profane language was used when the child was in the yard by himself, and that then the mom went out and made a statement. She said she never remembered calling anybody Mickey Mouse. Seems like that's something you would remember. But it's just contradicted by what Mr. Danielson has testified to. So I think that's an issue the jury's going to have to decide, and I have to look at it in the light most favorable to the state, because that's what the rule is. So I'm going to decline to grant a directed verdict. If y'all don't have any other additions to the charge, then if y'all want to take a quick restroom break, we're going to move right into closing argument, and I'm going to move right into charge as soon as we get done with closing argument. I think the law says you have an hour, but surely to goodness y'all not going to argue an hour apiece on this. Okay.
I've debated on 30 seconds, but I'm going to give 10 minutes, maybe. Maybe 15.
And I'm not going to send a charge packet out to the jury because I think it's a waste of paper. I mean, it's pretty simple. It's one charge. So I'm just going to read it to them, and then if they ask a question, then we can reconsider that. But you okay with that, Ms. Postman?
Yes, Judge.
Mr. Tumlin?
Yes, sir. And I'm ready to go unless somebody else in the courtroom needs a break.
I would like to go use the restroom, please.
Are you going to open and conclude, or just conclude? You're going to open and conclude? All right, just so Mr. Tumlin can expect.
Thank you.
All right, let's take a 2-minute restroom break, and we'll come back and pick right up.
I don't even know why she denied Mickey Mouse. You can call someone Mickey Mouse. That's fine. That's legal.
And Judge, I'm going to step down to our office just in case jurors are up here.
Yes, ma'am. They should be up there. They're in there.
Oh my God, my neighbors. That woman screams and swears at her kids all day long, every day, for years, since they were tiny little, all day long.
You go wherever you want to, but they're in their room. They got a bathroom back there.
I went to sleep yesterday and ran into a whole bunch of them.
All right.
Thank you.
Confusing because it says, but then the statute says, which threatens an immediate breach of the peace, which that sounds like that's what fighting words are. So, I agree with the Court of Appeals opinion that say we hope the Supreme Court can clear this up. This is misleading and confusing. So we'll be fine.
Imagine this girl in
Welcome to Lisa.
All right. I don't know if y'all got your baby for it. You want to air it out?
Yeah, you're on track. Yeah, right. But if you Chris to Toronto, they'll let you know. They told you. Yeah.
Going after the
All right, everyone, please be seated. Ladies and gentlemen, we're going to move into the next phase of the trial, which is closing arguments. And the state has the burden of proof, so they get a chance to open and conclude closing arguments. Ms. Postman.
Thank you, Judge. On behalf of the state, Mr. Danielson and Mr. Tumlin, thank you all again for your attention and diligence during the presentation of evidence. We appreciate you. So I just want to talk a little bit about the law before I get into the facts. The judge is going to give you jury instructions, and he's going to present the law to you. But I just want to really highlight that Mr. Danielson is presumed innocent, and it is a great burden that is on the state to prove him guilty beyond a reasonable doubt. And this is not a burden that the state takes lightly. So to rebut that presumption, the state must prove each element beyond a reasonable doubt. Now, reasonable doubt, I just want to read to you what I anticipate the judge is going to give you in regards to the jury instruction. The state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. Reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which reason can be given, arising from consideration of the evidence, lack of evidence, or a conflict in the evidence. So, Mr. Tumlin is going to get up here and he's going to present his side of the story like they have. Mr. Tumlin is going to try to poke holes in the state's case. But what the state really wants to implore you to think about in this case is it's not beyond an unreasonable doubt. It's just using your common sense and reason in coming to a conclusion of whether or not, on this particular date, the state can prove guilt beyond a reasonable doubt based upon the accusation. And in the accusation, Mr. Danielson is charged with disorderly conduct for, on the 28th day of August 2025, without provocation, he did use obscene, vulgar, and profane language in the presence of Luke Adams, a person under the age of 14, by stating to that child that said accused was tired of hearing said child effing dogs, which threatens an immediate breach of the peace in violation of Code Section 161139. Now, I like to think of the accusation, which is the charging document, as a toolbox, right? How are you going to get to find guilt beyond a reasonable doubt in this case? Normally how I present it is to break it down into questions, right? So the judge, again, is going to go over disorderly conduct with you guys. And I break it down into elements. So, without provocation. Use this profane language in the presence of a person under the age of 14, which threatens an immediate breach of the peace. And I'm going to come back before you after Mr. Tumlin gives his closing argument and go over those again with the facts that you've heard based on the evidence and the testimony provided in this case. But I just also want to point out to you that you're the I almost said determinators, but you make the determination of the credibility of the witnesses. You get to look, and the judge is going to instruct you in the law of this, but you get to look at how the witnesses testify, how you believe that their demeanor was, the way that they looked, how they felt, how they described the incident. Those are all credibility determinations that you, ladies and gentlemen of the jury, get to decide. And I just want to implore you to just use your common sense and reason based on what you've heard in this case. And a single witness, if believed, is enough to prove guilt beyond a reasonable doubt. And I'll come back before you in just a few minutes.
Mr. Tumlin.
May it please the court. Lord, have mercy the lives that were told on that witness stand this week in front of you and to this jury, and the worst of which came from the arresting officer on the case. I want to review her testimony. On August the 28th of 2025, at around 8:30, she comes over to the house of the Adams to investigate a crime that had allegedly occurred around 4 p.m. earlier that same day. You're watching the video of this officer. She is sitting there driving, looking at the map on her phone to get to this house. And when I asked her about it, just for normal conversation, no, I was following the orders of my boss. Lies about something that little should concern you, because what else is she lying about? She came in here and she told you, she walked up to the scene. She talked to Mr.
Kristen, and I know I probably said that wrong. It might be, I don't know. It's Kristen. You know what? It's Kristen Postma. The prosecutor's name is Kristen Postma. Now, it's possible that was cut off, and you're going to see what I see as soon as they're done.
Adams. And Mr. Adams told her, and she had already had the 911 call, remember? The 911 call saying, this man, John Danielson, cussed at my child in the backyard and said these things. Do you remember that? She already had made up her mind. She even told John Danielson, essentially, I don't care what you have to say. I got multiple witnesses who said that you cussed at this child, right? That's what she said. Well, let's talk about who those witnesses turned out to be. She said that Mr. Woods, the neighbor across the street, had came over into the backyard and was able to witness and hear the commotion. Lies. He said from the witness stand.
He said he did it, sir. He said that he admitted the guilt. Are you trying to say maybe he didn't do it? Come on.
He was in his driveway working on his Jeep with his family and was walking down the driveway and heard something to the tune of, put your fucking dogs up, or something like that. But he testified on this witness stand. I did not see John Danielson say that. I did not see Luke Adams in the backyard. I never was in the backyard. All I did was heard a commotion, so as a concerned neighbor, I came down. That is important because he's not a corroborating witness that Officer Munchausen said she had, right? Let's look at the next witness, corroborating witness, Kendra. She said that the mom had heard. The mom told you on that witness stand she was in the house at all times. She did not hear John Danielson say anything. I think that was the testimony. She was not out there because she just heard what her son said, okay? So no corroborating witness of what was exactly said. But then we have John Danielson get on this stand and tell you, I'm in my yard at 4 p.m. dealing with my flower beds and the dogs that have been wreaking havoc on me for 5 years are going at it again, this time with earphones on, and I still can't handle it, right? So he says, do something about your dogs, and yells it out there. And then, say something, Mickey Mouse. Well, that's important because he's got Mickey Mouse things in his yard. There's Disney memorabilia in the backyard. He told you why she would say something like that, because she's looking up the hill, seeing and observing things that appear to be Disney-like. And so,
Yep, that's important, he says. That because he has Disney stuff in his yard.
she tried to piss him off, right? She said that up there to try to get a dig out of him and try to piss him off. And guess what? It worked. Because when she came out, when she was there, he said, screamed at her, just put your fucking dogs up. Now, he did not say, you fucking idiot, I'm going to do this or that, right? Nothing to her. This is all about the dogs, people. It's all about the dogs. He's so frustrated and terrorized by these dogs, and it's important to you because when Judge Deal charges you on the law of this case, the very first element that you have to look at is without provocation. Did John Danielson say fuck? Or put the dogs up, using that word. That was in the presence of a 14-year-old, and you have to find beyond a reasonable doubt it happened in the presence of a 14-year-old. And then you have to find it was an immediate breach of the peace. Judge Steele, you listen to him when he says it. He's not going to say that results in a breach of the peace or a possible breach of the peace. He's going to tell you the law is what was said must be without provocation. Profane language. We admit he used profane language. You can find he used profane language. I'm not disputing that. He's not disputing that. No one's disputing that. he said, put your fucking dogs up. Because she provoked him. Had she put her dogs up, it would have stopped it. Can you put your dogs up? That's what this case would be. Say something, Mickey Mouse. And he said what he said. So, he was provoked, and the state's case will fail on that element alone if you find that he was provoked. The judge is going to tell you it's a critical, essential element of the case, and you have to find beyond a reasonable doubt that he was not provoked in order for you to find him guilty. Element number 2 of the offense, we've already said, he said. Okay, count 3, in the presence of a 14-year-old, someone 14 or younger. That's what the statute prohibits, right? But the judge is also going to talk to you about criminal intent, right? This is not criminal negligence. It's not knew or should have known, right? It's going to be that state has to prove John Danielson knew that child was in the yard because the child was in the yard and he said it directly to him with a criminal intention to violate the statute. The judge is going to tell you that. And if you have reason in your mind to believe that Luke Adams was never in the yard when John Danielson said that, in other words, if you believe John Danielson, that he was gardening in his bed on the far side of the house, and he was looking out towards the property, and he never saw Luke Adams over there, or did not believe Luke Adams was out in the yard with his dogs on that particular time when he had that spontaneous outburst in response to Kendra's provocation, if it's reasonable for you to believe that Luke wasn't out there and John didn't say it to the child, then you have to acquit. The judge is going to tell you it's your duty to acquit if you find John's testimony reasonable to believe. You can even believe Kendra if you want. But if it's reasonable to believe them both, the judge will tell you it's your duty to acquit because that's a doubt over the law. But
I'm going to get that lawyer.
because the state hasn't proved their case beyond a reasonable doubt. When we are in court, we don't convict people on, well, this might have happened, or it could have happened, or I really don't know, because you might be, out in your truck one day, or you might be at the library, or over there at Senior Fiesta thinking, I wonder if John actually knew that kid was in the yard, right? And then it's too late if you make the wrong decision today. Element number 4, immediate breach of the peace. Why is that word in there, right? Let's talk about why immediate is in the statute. I believe the statute, and I submit to you the statute, is designed to not use offensive or opprobrious language, profane in this case, that is designed to immediately disrupt and breach the peace. What does that even mean, breach the peace? Does it mean I was scared? I don't think so. Or they would use language such as to cause fear or safety. It says breach of peace. Those are the words used in the statute, but more importantly, the adjective immediate. Here's what is uncontested in the case. It happened at 4 p.m. Child came in. No one called law enforcement. No one came up to talk to John. They went to the baseball game. Came home at 8:30. And then on the video, Dad says, yeah, we weren't home when it happened, but this happened. Yes, you were home. Yes, you were home. You were inside the house. And you got on that witness stand, and you told Judge Deal, and you told you guys, I was home. I was in the house. I didn't hear what Luke said.
Okay, he did look like Judge Leopold T, but that's not his name. It sounds like he's saying Dale, Judge Dale, but that's not his name.
But remember the video? The officer comes in. Dad told me that he cussed at my kid. Dad didn't say my child said this is what he said. Dad said he did. And that police officer says, based on what the dad said, I have a corroborating witness. Okay? And then she said from that witness stand, Officer McCheeson, well, if Dad got under here and said under oath he didn't see it or have first-hand knowledge of it, then that would surprise her. I think that was her testimony, right? Ladies and gentlemen,
This judge has to be Judge Jason J. Deal. That's his name. Deal.
it's the little lies that just blow me away in jury trials. This family gets up here and tells you we have all these dogs. We take them out for no more than 15 minutes at a time. We take them out one at a time and never more than one at a time. There are 4 dogs that go out about 4 or 5 times a day. And you remember when I talked to this guy about, so the math is the dogs go out about 16 to 20 times a day, right? 4 dogs, 1 at a time. 4 times is 16. If you do it 5 times, it's up to 20. But Dad wants you to believe we keep these dogs in the house. They are never outside. We take them out 1 at a time. And then this is another one. Only I or my son takes the dog out. Nobody else takes the dogs out. What did Kendra tell you? Yeah, I take the dogs out. I take multiple dogs out at a time. Who's lying? One of them is. You ought to be upset about that. As a juror sitting here trying to figure out whether John Daniel's a criminal or not. Right? I just always hate it when little kids have to get on the witness stand. I mean, that
We never see her. Why doesn't she stream? There's 5 Superior Court judges. And he's the only one. I don't know if I see the other ones. Maybe Clint G. Bearden is the adorable judge. But why doesn't she stream? She should stream more often.
like a cool little kid, you know, with his buttoned up shirt and all that. And he got up here and he told you what Mr. John said. And he told you, very affirmative, what he said. And he told you that Mr. John was up on the hill 200 feet away, right? It's 10 years old, using terminology, 200 feet away. Then I asked him other important questions, you know. Well, what about this? I don't recall. Well, what about this? Not that I can recall, right? And then I said, did anybody talk to you about your testimony today and what to say? No, nobody talked to me. I haven't talked to anybody about my case at all. You know what? You know what I do believe him on? He never talked to Officer McCheeson about the case, because guess what? If this whole crime that she made her mind up to arrest him without even knowing the facts is about what he said to this child, why did she not go inside the house and say, hey, Luke, I'm at the time Deputy McCheeson from Dawson County. You know, I heard you heard something in the backyard. Can you tell me what you heard? You know, how that make you feel? She's got a video dash cam or a body cam to get Dad on the thing saying what he had to say. But she didn't, you know what, ladies and gentlemen, she didn't care what this boy had to say. She didn't care because she was led astray with lies by the report of the incident about 5 hours after it actually happened. And I submit to you that's not an immediate breach of the peace. If it's even a breach of the peace at all. If the child heard it, I hate that he heard it. One thing Ms. Postman and I agree on is kids probably shouldn't have to hear adults shouting and saying that word, right? I've got a 9-year-old in college, I've got a 6-year-old in college. They've heard the word. I know it. Kid said he's heard it in a song in Mama's car on the radio, the music she plays, right? He's heard the word. He's got a sign saying they are those motherfuckers about the Braves, you know, when they run their run, and, you know, it was fun. The World Series, you know, that was fun. This kid's not offended by the word. The word's not the issue, right? It's John shouting that's the issue, but I submit to you, ladies and gentlemen, that John did not know that child was in the backyard. John did not say those words with knowledge that the child was in the backyard, if he was in the backyard at all. That alone is enough for you to find him not guilty, okay? I just find it outright offensive when these folks get up on the witness stand and tell you that these dogs stay in the house at all times. When they told you from the minute they moved in, the Danielsons say from the minute they moved in, it's this dog yapping, yelling, jumping at the back door, launching it himself. No doggy door to get in and out. Has to launch themselves into the door to alert the owners to come in and let them in because they're outside just disrupting the neighborhood. You know what? Those dogs breach the peace. That's provocation. Well, long provocation of them not taking care of their dogs. The other neighbors, when they have a dog bark, they move them inside. John and his wife, when their dog barks, they move it inside. Everybody moves their dogs inside, or quiets their dogs, or handles the situation, except the Adams, because they don't care. They go in their home and lock the door, and they don't answer when people knock to talk about a situation. They don't respond whatsoever off the back porch or whatnot, except for something to the tune of say something to Mickey Mouse to try to piss John off, right? You know, if y'all convict this man because he said fuck, I might as well just get a billboard out there on 400 that says, say fuck, call that, you know? I might even get a 1-800 number, like 1-800-FUCK-LAW or something, you know, where you can call me if somebody said fuck. But I don't want to have to do that. Because this ain't criminal, right? What I know and I believe and I submit to you is this is not criminal. It's regrettable. John told you he regrets it. He told the officer on the camera he was sorry. Guess what? She didn't care. She didn't offer to get the parties together and resolve it. She made up her mind to arrest him, and it came out in court that the basis for which she did it was simply not true. No corroborating witnesses, a child who made a statement with no recording of the child to preserve it so that you know what the child was saying back when it said over 6 months ago. Ladies and gentlemen, I ask that you find this man not guilty. Do not make him a criminal because of the state's flimsy accusation that has dragged us into court to hear about this. If anything, I hope that Officer McCheeson will go forward properly investigating cases.
I wonder if it's appropriate for this lawyer to say, if this can happen to him, it can happen to you. Because every single juror on there has swore in front of a child before. Every single one of them.
Properly taking statements, ruling out things that aren't violation of the law. She got up here and tried to quote to you the law and then had to admit to me on cross-examination that the first 3 statutes actually don't apply. What we're dealing with here is, did he say put the fucking dogs up? Okay? They've not proved element 1, they've not proved element 3, they've not proved element 4. The only thing that they proved to you is he said fucking, that ain't true. Not guilty. Not guilty, not guilty, not guilty, not guilty. I ask you to take about 30 seconds to reach that verdict, please. Thank you.
Ms. Postman.
Thank you, Judge.
Stop. What the hell was that? What was that?
All right. Intent. Mr. Tumlin brought up intent. Again, the judge is going to direct you on the law. Intent can be shown in many ways, provided that you believe it existed from proven facts. It can be inferred from proven circumstances or by acts or conduct, or it may be in your discretion inferred. I love distractions. Distractions are fun. The Mickey Mouse comment. Ms. Kendra was up here, she testified, she doesn't remember saying that. What she remembers hearing is a commotion in the backyard. Distraction number 2, lying on the witness stand. Mr. Tumlin is asking you to believe that Luke, who was in the backyard, who took this witness stand as a 10-year-old child, lied on the stand. He's asking you to believe that Luke's story is not the correct story. The state hasn't alleged that Mr. Danielson yelled and screamed curse words at Michael Adams. The state's not alleging that John Danielson screamed curse words and profanities at Kendra Adams. The state is alleging that Mr. Danielson, knowing the child lived at that home, he testified to that, knowing that he took the dogs outside, Luke took the dogs outside on a regular basis. I think everyone in this room could agree that dogs that bark are annoying. I believe both myself and Mr. Tumlin, or actually I believe it was Mr. Tumlin that asked that on board diary. Would everyone agree that dogs barking incessantly are annoying? I think everyone in the jury pool said yes. But whether or not Mr. Danielson knew that Luke Adams was in the backyard, That's a determination for you to make. He knew that Luke lived there. He knew that Luke took the dogs out. On this particular day, Luke testified that he had gone outside with the dogs. The dogs were playing like dogs do. And Mr. John screamed down the F word, "Take your effing dogs inside," to him. He ran immediately inside to tell his mom. His mom testified that he looked scared. His dad testified that he looked scared. He described Mr. Danielson's screaming as like a rage, like it was scary to him. Ladies and gentlemen, for a 10-year-old, an immediate breach of the peace, he was fearful. He was scared. I don't believe that any 10-year-old wants to be screamed at. Mr. Danielson and his wife both got on the stand today, and they both testified that the dogs had barked. They also walked down there one time to try to confront the Adams about the dogs. You heard from Mr. Woods, who testified that he heard Mr. Danielson scream this on this particular day. A neighbor that lived across the street from the Adams residence. A single witness, if believed, is enough. The state just wants to remind you to really hone back in on Luke's testimony. Luke, a 10-year-old kid who was just doing what he was asked to do, take the dogs out on this particular day, and gets yelled at by his neighbor, who knows that he's living there and has lived there for quite some time. Ladies and gentlemen, I ask that you find Mr. Danielson guilty beyond a reasonable doubt, because on this particular day, there was no provocation for Luke Adams, who was yelled at in the backyard while taking the dogs out. Thank you.
All right, ladies and gentlemen, we're now going to move to the next phase of the trial, which is the charge from the court. I wish I could tell you this is exciting, but it's not. I'm going to read you the law, and I'm not near as exciting as either one of these attorneys, but this is important, so please give me your attention. Ladies and gentlemen, you're considering the case of State of Georgia versus John.
I am going to listen to this because I have to know what the law is on this charge of swearing in front of a minor, and not what the lawyers said the charge is. I need to know what the judge says the law is.
John Paul Danielson, the district attorney for the Northeastern Judicial Circuit, has accused and charged the defendant with the offense of disorderly conduct. The accusation reads as follows. I, Lee Dara, district attorney for the Northeastern Judicial Circuit of Georgia, charge and accuse John Paul Danielson with the offense of disorderly conduct for that the said accused in the county of Dawson and the state of Georgia on the 28th day of August 2025, without provocation, did use obscene, vulgar, and profane language in the presence of Luke Adams, a person under the age of 14, by stating to said child that said accused was tired of hearing said child's fucking dogs, which threatens an immediate breach of the peace in violation of OCGA 16-11-39, contrary to the laws of this state, the good order, peace, and dignity thereof. The defendant has entered a plea of not guilty to the accusation. The accusation and the plea form the issue that you are to decide. Neither the accusation nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you, beyond a reasonable doubt, that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the accusation and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from the consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on the law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. It also includes stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the accusation, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence...
Wait. Holly, if you played this case when your kids were awake, you could call the police on me. You could call the police on me for letting swear words happen in front of someone 14 years or under.
Whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct. Or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. The law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution, venue, that is, the crime was committed in Dawson County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt, just as any element of the offense. Venue must be proved by direct or circumstantial evidence, or both. A person commits the offense of disorderly conduct when such person commits each of the following elements. A, without provocation. B, uses profane language. C, in the presence of a person under the age of 14. And D, which threatens an immediate breach of the peace. Ladies and gentlemen, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Dawson County, Georgia, did on or about August 28, 2025, commit the offense of disorderly conduct as alleged in the accusation. You will be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of your number to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. And we prepared a verdict form for you, so it has a place for you to reflect your verdict and a place for the foreperson to sign and date it. Ladies and gentlemen, you may now retire to the jury room, but do not begin your deliberations until you receive the accusation and any evidence that's been admitted into the case. I'll let you go with the bailiffs here. I'm just going to send out the original. Normally we would, but they joined issue on this original. We'll just send it out. And since it's not an indictment, they have grand jurors' names on it. All right, I've got the original accusation and a clean verdict form. Show that to the parties, and then we also have defense exhibit number 1, which I think is the only exhibit that's not a record exhibit, or not an exhibit that can't go out to the jury.
Yep.
Everybody agree that that's what goes to the jury?
Looks good.
All right. And States 1 was the 911 call, and States 2 was the body cam, but those are on the jump drive. Don't go out to the jury. You agree,
Yes.
Ms. Postma?
I agree.
Yes.
Mr. Tomlin? You agree?
Yes, sir.
All right, very good. All right. take that back to the jury. Any exceptions to the charge, Ms. Postma?
No, Judge.
Mr. Tunley?
No, Your Honor.
All right, very good. Well, I would say hang around, and we'll see what happens. I imagine before lunchtime, we'll have an answer.
Thank you so much, Judge. All right, I will, if you want to go take a little break, I'll text you. Don't go far. I don't expect it'll take long. Okay.
So he shut down the live stream. I did. I wrote a piece of code that was supposed to watch this court all day long and just pick it right back up again. But I think when he shut down the live stream, if you want to get geeky, it refreshed the token and it didn't work. But it's okay. Don't worry. Don't worry. We actually spent enough time, but I do have this. Boom. Disorderly conduct, not guilty. He was not guilty. He did not get charged for that. But if you look under attorneys, Bobby, if you look under attorneys, is that Kristen Postma? That's who we're looking at, I think. But how do you say that? That's not Christian. It's not Christian, right? Because Christian is a man's name, isn't it? How do you pronounce Kristian? And I wonder if her last name is Postma or if that's truncated. I've never heard of a Postma before. Okay, guys, come on. You can't get charged with swearing. You can't. The jury couldn't have found him guilty of swearing because people swear all of the time. You think it's Christian? Kristen. Yeah, okay, I got Christian and I got Kristen, and now I'm still confused because you both said two different things. But, I mean, okay, I know not everybody in chat has swore in front of a child before. But most of us do it frequently. Most of us do. And Holly, I was with you when my kids were growing up. It was, oh, sugar. Gosh darn it. That freaking cat. They weren't even allowed to play Halo. They weren't. They just weren't. But that was a different world. That was so long ago. And like, when I got divorced, the first thing we did, me and the kids did, as soon as he was gone, like the week he was gone, I'm like, God, in the car, you guys can say anything you want. When we're in the car, you can say anything you want. You can't get in trouble for anything you say in the car. So me and my kids, it was like my rebellion against the whole world. I like, my kids are going to swear in the car. And we did. And then as they grew older, it spilled out of the car. That was all over the place. But yeah, when I my middle child is a saint. She really does no wrong. She does not. But she does have a mouth on her sometimes in public. And she doesn't have that mouth like in the house and things like that. It's just like when we're in public, all of a sudden, my middle child, she's 22 right now. No, she's 25 right now. Damn, I just lost 3 years of her life just like that. So that is, but the thing is, right? The world has changed from when we were growing up. Those words that everybody is still marking as swear words, they're just regular words. They're just regular words to these kids now. They're not really, they don't hold the weight of being offensive. So why is that F word a swear word? Because in our generation, we took offense when someone said that. Well, they don't take offense to that word anymore. So, I don't know. I don't know who gets to decide what words are offensive and swear words. And it's definitely not forever. One word is not a swear word forever. I'm struggling to think of one right now because it's a live stream and I really can't think straight during a live stream. But I know there were words from like 20, 30, 40, 50, 60 years ago that were, unbelievably horrible to hear. And we say them easily now with no issue. But back then it would have been, oh, clutch my pearls. But, so, yeah, they couldn't have found him guilty. They really just couldn't have found him guilty. And I don't know why he didn't mention free speech, freedom of speech a little louder during that, because that's pretty much a big freaking deal that we have freedom of speech, right? Yeah, Hedwig's. I didn't swear that much when my kids were little, but they all swear now, and everybody swears now. Every job you work at, there's swearing going on, and that's your job. Every YouTube video you see, there's swearing going on. There's nowhere for them to get out of it. It's not like, oh, I heard the F word today. If I came on the street tomorrow morning and opened up to say, guys, you will not believe the day I heard the F word. That would not be shocking to anyone at all. So, yeah, it was waste. I can't believe it went that far. I'm guessing, I'm wrong too. My dad never swore, never. But again, it's from a different age. He was from a different age. But what I was saying, that I was about to guess that he paid $2,500 for this lawyer. And I'm wrong, absolutely wrong. This was a 2-day trial. See, now, the C word is still pretty offensive. The F word is not. The F word is dropped everywhere constantly. So, not very many people get offended by that. The C word here still is pretty offensive to people. I don't know why that word survived the test of time, but, S, D, F, all those words, they're frequent. Cash money. I don't know why. I just can't see how they could have found him guilty. Because if they would have found him guilty, we would have 2-day trials all over the place. I know I would always be in court. Always. Because, just like last night. Oh, I can't. Damn it, I can't tell you this story because it's political. Son of a gun. Okay. I'm going to try to tell you a story without making it political. Okay? Here's what I'm going to say. I'm going to say, me and my daughter were talking about Gone with the Wind. Okay? At the end of Gone with the Wind, frankly, my dear, I don't give a damn, was at the end of Gone with the Wind. Okay? But I was confused because I'm an old person and sometimes my memories mash together. And I'm like, Tiff, I just don't understand. Gone with the Wind is, I can't tell this story without being political. Gone with the Wind, was Civil War. But I clearly remember Humphrey Bogart standing in an airfield saying this line to her. So if you know what I'm talking about, I just got two two major stories mixed up. Okay? And we were trying to unravel this. At some point in the past, a person of authority in the United States mentioned how there were airplanes in the Civil War. And I loudly said that this person was a fucking idiot. That's what I said, right? We were in a diner. And I said, I went on a little bit from that, complaining about one or two other things that this person of authority has done recently. And I was animated, and my daughter was animated, right? Well, the person at the next table was very offended about my words, which only made me giggle and say more and talk louder and offend this person even more. But, I mean, he wasn't offended because I used the F word. But I did use the F word in a restaurant. I did yesterday. And it was not a big deal. Okay. But I would be arrested. If this guy was found guilty, I would be arrested. I would have been arrested yesterday for saying that, which was awesome because he kept getting more and more mad. So I kept going louder. I'm looking at my daughter. She doesn't know this whole family is angry at me. She doesn't know. She's taking my words and she's getting animated too. And then he did this and this and this. And they are super pissed. And I am love it. It's the best dinner I had in a long time. But I would have been arrested. She would have been arrested because we swore. There were swear words. So he had to have been found not guilty. But the movie I was talking about, I got Casablanca mixed up with Gone with the Wind in my head. At the end of Casablanca, he says something. I don't remember now. I don't remember, but I got those. That's how it started out. I got those two mixed up, and we were talking about that. And then it turned political. And then they were mad at me, and it was great. So, I do have this. This judge didn't only do that trial yesterday.
Language that...
Hold on. So, we're just going to watch this for a few minutes.
Language that did not fall under the Constitution. Language that did not fall under the constitutional protection of free speech, but that is not what we're dealing with here, Judge. Make no mistake about it. What we're dealing with here is a statement made from over 200 feet away concerning property, a desire, a shouting, angrily frustrated desire for my client to tell whoever was on the other end of that fence to take care of their personal property in such a manner to quit breaching the peace. Judge, the next witness was Kendra, the child's mother, who testified she was in the house and she did not hear the statement uttered towards her. She did not language.
Hold on.
That
I can't find it. This is all I had for today, but I'm going to keep going. I just need to find this stupid video. All right, Dawson GA. That's what I put on, isn't it? No. I don't have anything else for today. I do not. I mean, I could put something on. I could just put something on. We can watch something. I didn't see this. I'm just hoping there's no child. Nothing in here. Let's go to here. This one's bigger.
Or an event has occurred.
Is this a trial?
State's Exhibit 5, please.
Darn it, it's a trial.
In State's Exhibit 5, this is again.
We can't watch that. It's a trial. So I'm saving that because I have to look at that first. How about Hall, Georgia? I got another Georgia ready. Ready. I'm using that term loosely. I don't even know what this is. Look at this. This is a totally different courtroom to what we're used to. Ow. They started the live stream for no frickin' reason. It's 6 hours. I recorded 6 hours. I recorded of an empty courtroom. No. Yes. Colorado.
And she knows various dialects for the Burmese people.
Right. Okay.
Oh, a
So
Burmese
we'll know that
interpreter?
We need a Hakachin interpreter for that date.
A Hakachin.
And he does have a few days to do under mandatory sentencing. He will go that day, correct?
That's
So
fine with
arrange
me.
it with us.
Yes.
He needs to know so he can tell his employer.
Okay. So yeah, he can go into custody on that same date.
Okay. Thank you, Judge.
Okay. You're welcome. You have a good rest of your day, Mr. Shaver.
Okay, and Maddie, will you send me that amended plea to show the credit time?
Yes, I will.
Thank you. Thank you, Judge.
Take care, Mr. Shaver.
You too. Bye-bye.
Bye-bye.
Jeremiah Bailey, 49D 362602C and 003817. Bailey in custody, initial hearing.
Hello, I'm here.
Good morning, Mr. Bailey.
Good morning.
Would you raise your right hand, sir?
I love Bailey's.
Swear or affirm under penalties of perjury, the testimony you're about to give will be the truth.
Swear.
That the testimony you're about to give will be the truth.
Swear.
Is that a yes?
Yes. I'm sorry. Yes. This is my first
That's
time.
okay. Okay, thank you. You may put your hand down. Are you able to hear me, sir?
Yes, I can hear you.
Okay, if there comes a time that you cannot hear me, let me know.
Understand.
So you're here for your initial hearing this morning. State your full name for me.
Jeremiah Jerome Bailey.
And Mr. Bailey, is your name spelled JeremiahBailey?
Yes.
Is your date of birth May the 16th, 2003?
Yes.
All right. Mr. Bailey, you've been charged with reckless driving, which is a Class C misdemeanor.
You know what sucks? I was tense and terrified the entire time that this was going to be a child something case. Because, guys, you don't even know. It is all day long in almost every docket. I have to pull these out. And it's crazy that I had to be worried about that. That should be like so rare that I shouldn't worry that this probably is, it was reckless driving or whatever, and I'm super relieved. And that's just not right. It's just not right, guys.
Charging information states on or about February the 8th, 2026, Jeremiah Bailey did operate a vehicle and recklessly drove at an unreasonably high rate of speed under the circumstances as to endanger the safety or property of others. Now, Mr. Bailey, a Class C misdemeanor carries a maximum penalty of 60 days in jail with a maximum fine of $500. A plea of not guilty will be entered for you today. You have the right to a public and speedy trial by jury. You have the right to confront and cross-examine witnesses against you. You have the right against self-incrimination, which means you do not have to say anything that is against your interest. You have a right to bail, and you have a right to be represented by an attorney. If you cannot afford an attorney, the court will appoint an attorney to represent you in this matter. Additionally, Mr. Bailey, because you've only been charged with a misdemeanor offense, you are entitled to what's called a bench trial, where the judge will hear the evidence. Although if you would like to have a trial by jury, sir, that request must be made in writing at least 10 days before your first court trial setting. Mr. Bailey, did my staff give you a copy of the charging information and your initial hearing right?
I know. I'm interrupting a very important case, but Sandra, I used to. When I first started, I didn't have a camera. I had a laptop, but I kept the camera off. And it was just, I just spoke every once in a while. Not as much as I do now. I know. But it was lovely. I could just like roll over and start streaming. And people would think that I'm awake and at a desk somewhere. No, I wasn't. I was not. I miss those days so much. I didn't have to worry about putting a presentable shirt on.
Yes.
And were you able to read and understand those documents?
Yes.
And did you sign the initial hearing? Right.
Yes.
All right, sir. Now, Mr. Bailey, do you have the money to hire an attorney to represent you in this matter?
I don't.
Are you working, sir?
Yes, I am. I was just getting off my shift. My bad. I'm sorry.
Where do you work?
Amazon.
Okay. Is that a full or a part-time job?
It's a full-time job.
And how long have you been there?
Going on about 9 months now. Okay.
Okay. And do you get paid weekly or bi-weekly, sir?
Every 2 weeks.
And what is your take-home pay approximately after taxes every 2 weeks?
1,000 after tax. 1,200, 1,300.
Okay. Who do you support besides yourself?
Just myself. I came back. My bad. I'm sorry.
So at the end of the month, so do you live by yourself?
Yes. I just got my own apartment.
Okay. So after you've paid the bills of that you have associated with your apartment and your car, about how much money do you have left at the end of the month?
300 to
Okay.
$400, but take away 100, I got 300 because you gotta spend money on groceries. So $300.
Okay. Do you have a checking or a savings account?
Yes, yes,
Approximately how much do you have in your account?
only 300 right now because I had registrations coming up that I was going to spend money for that. I just paid rent. It's a lot, but it's only me. So
Okay. So I will appoint the Public Defender's Agency to represent you in this matter, Mr. Bailey. Good morning, Mr. Manning.
Good morning, Your Honor.
This is Mr. Bailey. And the omnibus date is March the 27th. Mr. Bailey, that is not a date for you to come back to court necessarily. That's a date for the lawyers to know for filing certain motions and defenses. How can I help you this morning, Mr. Manning?
Your Honor, if the state is prepared, would the court permit us to conduct a bail review at this time?
Ms. Eisenberg, are you ready to proceed with the bond review this morning?
Yes.
All right. Mr. Bailey has been sworn in. Mr. Manning, your witness.
Thank you. Mr. Bailey, where do you reside?
Where do I live?
Yes.
My address on my ID or
Where do you live?
Circle City.
How long have you lived in Marion County?
All of my life.
All of your life? You mentioned earlier that you are employed with Amazon.
Yes.
If you were released, will you still have that job?
Yes.
Have you ever been charged with a criminal offense before?
This is my first time. Never.
If the court were to release you, you must attend your future court hearings. You're aware of that?
I will be here. Yes.
You have the ability to do that?
Yes.
If you are released, you must maintain contact with your attorney.
Yeah.
Do you have a phone to do that?
Gotta pay my phone. Yes.
Okay. No further questions, Your Honor.
All right. Cross, Ms. Eisenberg.
None, Your Honor.
What's the state's position on bond?
The state has no objection.
All right. Mr. Bailey, I'm going to release you on your own recognizance, which means you will not have to post the bond, all right?
Is that all more? Thank you.
How would you like this matter set, Mr. Manning?
Your Honor, we would request a pretrial in due course and discovery from the state.
Local rules of discovery apply. Let's set Mr. Bailey for, he's a Monday case, so that would be a pretrial conference on April 13, 8:30 in the morning, Mr. Bailey, right back in the same courtroom that you're in right now. All right?
Yes, I will be here.
All right. That will conclude this hearing this morning. You have a good rest of your day.
You as well.
Thank you,
Thank
Judge.
you.
Boubacar Madgi, MAIDAGI, 49D 362506 F6018253. Judge, this is a status of counsel hearing. I don't have this defendant checked in, but our French interpreter is needed somewhere else.
I'm sorry. How did you spell the last name?
M as in Monday, AID.
What in the world is she doing?
Okay.
Is she locked up? Oh gosh, no. Is the woman in the top right locked up?
And this was set for a status of counsel hearing this morning?
Correct.
No, what did she do?
And the defendant is not present remotely or in person?
Correct.
Okay. Bear with me just a second.
I used to have a waterbed. It wasn't mine, it was my parents'. I loved it. But I'm not buying one because I can't lift it.
All right, defendant fails to appear.
Nan participated in a few. I saw that, Nan.
Remotely or in person. Defendant was summoned into court, fails to appear. Court will issue a warrant for failure to appear and set bond in the amount of $1,000 cash. Thank you.
Ricardo Mendez Alvarado, 49D 362511 F6036318. Mendez Alvarado, Attorney's Conference.
Your Honor.
Good morning, Mr. Gilly. How are you?
I am well. So good to hear your voice.
Good to see you also. How can I help you with this attorney conference?
Yes, Judge, we're waiting a plea offer. I believe that we can get this case resolved short of trial.
Okay, so you need an offer. And you want me to set this for another attorney conference remotely?
That'd be great, Judge.
Okay. How's April 5? I'm sorry, this is a Tuesday case. April 7
That'd be great, Judge.
April 7, 9 o'clock in the morning, attorney conference remote.
Perfect.
All right, thanks so much. Have a good rest of your day.
You too. Thank you, Judge.
Okay, bye-bye.
Bye-bye.
You're on Reed 49D 362510 F6029971. Reed pretrial conference. They called in remotely.
Yes.
Good morning.
Good morning, Judge.
And Mr. Reed, I don't see your attorney with us this morning. Bear with me just a second, all right?
Judge, it looks like the attorney's office filed a motion to withdraw their appearance on this case.
All right, let me see.
Mr. Reed, what did you do to
Let me
your
pull that
attorney?
file up.
Then I believe the PD's off.
Even if they filed a motion to withdraw, they're not allowed to withdraw unless the judge tells them they're allowed. So they should be here. Show cause. Sanctions, please. Sanctions.
This was appointed as well.
Oh, never mind.
Okay.
Never mind. They did. They were kicked off.
Thank you, Jamie.
Thank you.
Okay. Where did you see the PDs were appointed?
I don't know if it was previously.
I see we were appointed on, sorry, Marcel Fonte here, Judge, December 9th, but that was previous to him hiring private counsel, it looks like.
Oh, there's only a couple seconds left in this recording.
I believe Mr. Manning was covering for Mr. Perkins, so I'm not sure if, I don't know if they were reappointed.
I don't see anything pursuant to the CCS on that.
Well, I see Mr. Perkins filed his appearance on December the 9th.
So he should be here.
So the defendant was set for a status of counsel hearing on December 9th. And private counsel had not filed their withdrawal yet, but they did subsequently. So Mr. Reed is represented by Public Defender's Agency. We just need to make sure that the appearance is linked into the case.
Thank you, Judge.
Okay, Mr. Duplantier, is this going to be your case or are you covering for Mr. Perkins?
I'll be covering for Mr. Perkins today, Your Honor.
Okay. And Mr. Reed is present with us this morning. How can I help you?
Thank you, Judge. The state did file a discovery compliance notice where we just were asked that the state rescind the discovery link to defense. We have not received that. We'd also request an offer from the state and a pretrial in due course.
Okay, so rescind discovery and an offer, correct? Yes. Okay.
Yes.
And Mr. Reed, you still live in Gary?
Yes.
Okay, so I'll set this next hearing remotely, all right, again? And then we'll see where we're at. Yes?
Would you permit me to ask Mr. Reed to provide
hold on a second. Mr. Manning, I thought Mr. Duplantier was covering this.
It was me, Your Honor.
Okay, so Mr. Reed, I apologize for the confusion, okay?
Okay.
Mr. Duplantier did say he was covering it.
Covering for Mr. Perkins, correct?
Yes, Your Honor.
Okay. And Mr. Reed, what's a good phone number your attorney can reach you at?
Area code 259.
Okay, you said 2.
I hate when they read the phone number back.
Thank you so much. Now, Mr. Manning.
Yes, Your Honor. May I pass along Mr. Perkins' phone number to Mr. Reed?
You may.
Mr. Reed, Mr. Perkins, your assigned attorney, his phone number is 31.
Okay, I got it.
Perfect, thank you.
All right. And so, is it your request also, Mr. Manning, that this be set for a pretrial conference?
Yes, Your Honor.
Okay. Mr. Reed, I'm going to set that for April 7, pretrial conference, April the 7th, 9 o'clock in the morning remotely. All right?
Yes, Your Honor. I actually, I have a case manager out there already.
I'm sorry, a case manager?
Yes, I have a case manager. And my case manager informed me when I spoke with my case manager, she informed me to let you know that because I am remotely attending court because of my location, that it is an inconvenience for me to continue with this device, which is why I have a case manager. She wanted me to bring it to your attention because I'm so far away.
And
I knew it. I knew that this guy was going to be crazy.
so you have a case manager on this case.
Yes, and my case told me, well, yes, and my case manager told me to bring it up to you that because I am not living in Marion County, she wanted me to ask you if you could remove this device from me having to do it, I guess, because I gotta come out there every time something goes wrong, and it's such an inconvenience. Like something was wrong with the
Okay.
system. Something was
Are,
wrong with the system, and I had to come to Marion County at the drop of a dime. I had to call off work.
are you talking about the alcohol monitoring?
It's a cell phone and it's a blower thing.
Okay, because I was confused. I didn't know what you were talking about. So you're talking about your alcohol monitoring through Marion
Yes,
County Community Correction.
yes. I'm
And
talking about
that
my
case
case manager. Yes.
Okay, all right, I'm with you. That is not set for a hearing today. I can set that for a hearing. Um, let's set that for a hearing on February 24th. February 24, 9 o'clock in the morning, remote, hearing on pretrial conditions of release.
Okay.
Thank you, Judge.
All right, Mr. Reed, we'll see you on February 24th, 9 o'clock in the morning for a remote hearing.
Okay, thank you.
All right.
I'm
Have a good rest of
interested.
your day, sir.
I'm interested in how his cases move forward because apparently he has cases. All right, guys, that was interesting. We got a dog case. I don't play much of dog cases because normally they're too sad. I just won't. But that one was not too sad. That one I think was satisfying that he was found not guilty. I mean, I didn't like the guy. Actually, I didn't like his wife more than I didn't like him. But and I would like to see him get his just desserts. But I also don't want swearing to be an arrestable offense. Just for personal reasons. But, all right. I do have a stream tonight. So come back later tonight. Other than that, stay warm, be good, and I'll see you all real soon. Bye, guys. Thank you so much. See ya.
I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so